My name is Bronwyn Blake. I know many of you. I'm the Chief Legal Officer here at Texas Advocacy Project. And I'm joined by two wonderful attorneys. I'm going to have them say a little bit about themselves. Let's start with you, Marshall.
Thanks, Bronwyn. It's so nice to be with you all today. My name is Marshall Bowen. I'm an attorney here in Austin. I currently, as of December, work for the Shield Ranch as general counsel and vice president, which is my family's ranching business. So I've kind of made a transition out of private practice, but I was previously an attorney in the Austin office of Butler Snow for 4.5 years. And before that, I clerked on the Supreme Court of Texas. And before that, on the Texas Court of Criminal Appeals. And I'm here today because I was the amicus counsel appointed by the Supreme Court of Texas to defend the Court of Appeals judgment in Stary versus Ethridge. And I argued this case in the Supreme Court of Texas at the end of October last fall. So I'm also a former TAP board member, so TAP is near and dear to my heart. So thanks so much for having me, Bronwyn.
Thank you so much for joining us. And we also have Michaela Clark with us.
Hi, everyone. Good afternoon. I am a managing attorney at Texas Advocacy Project and got to see Marshall in action argue this in front of the Supreme Court in the fall. Prior to joining TAP, I was a prosecutor in Harris County for several years and then worked at another nonprofit supporting survivors of violence. And I'm excited to be here today.
Thank you, guys. Will somebody confirm for me that the screen looks normal? I know sometimes when I move the remote control around, it like puts a gray box. Is it good for everybody?
Looks good.
That's good.
Looks great.
Okay,
Looks
thank
good.
you, guys. Appreciate it. Well, great. Let's go ahead and jump in. I want to kind of just set the table really first and let you know, the Supreme Court of Texas, highest court in our state. So when they make a ruling like this, it becomes the law of the land, but just for our state. And even though it's not a law in our law book, it has the same weight. In fact, things that happen in a case like this could become memorialized in a law in a future legislative session here in Texas. So the other thing that's good for y'all to know is that obviously Texas is such a big state. Just because this important case came out and this change to the law happened, not everybody's going to know about it. Even some judges are not going to know about this, especially at first. So we want to make sure all of you know about it and you're prepared to understand the implications, but also don't be surprised if out in the world, you might be the one who knows the most about it after today. So we'll go through the procedural history of the situation of the case and then talk about the impact for all of us. Okay, you guys are here with us at Texas Advocacy Project. Michaela and I love to brag about where we work, but I think all of you all are aware, we love to get referrals from you for all these different kinds of victimizations. So just a little plug before we get too far. And I think we have another slide about bragging, right, Michaela?
Yes, I can handle that if you want. I love
Great.
to talk about us. So this is just a snapshot of who we are and who we've helped. These numbers are specifically in 2024. So we serve all Texans. And in 2024, we helped over 11,000 clients and their children across Texas. We did start as a legal hotline in the 80s, and we continue to offer that service today. So just looking again at who we serve. So we're serving not only children, but adults. So it looks like in 2024, we served clients from ages 15 all the way up to 93 years old. Another place I really want to brag about us is our amazing social working workers and their services they provide to our victims. So just know that we not only provide free legal services, but we also have incredible social workers that support our clients as well. And then I think those were the main things I wanted to highlight on this slide, unless you had any.
For sure. No, that's great. Well, thank you for the commercial interruption. Michaela and I love working at TAP, and we're so grateful to all of you for supporting us, especially board members and former board members like Marshall. But keep the referrals coming, please. So let's go ahead and jump into this case. I'll tell you a little bit, and then if I've left something key out, Marshall or Michaela can jump in. But we have two parents here, Christine Stary and Brady Ethridge, and they got divorced back in 2018. And they agreed they would share custody of 3 children that they had together, different ages, right? But fast forward 2 years later, in March of 2020, Christine Stary was arrested, and she was actually charged with felony injury to a child. We're not going to go into a lot of details without a trigger warning for y'all who don't like to hear it, but the charges were dismissed against her up in February 2025. The father, Brady Ethridge, had applied for a protective order 1 week after her arrest. So really fresh, she's arrested and he applies for the protective order. And in there, he said, I'm alleging family violence. I need an order that's going to last longer than 2 years because it's a high level of violence. And the trial court went ahead and issued a temporary order. And in that order, they said, Christine Stary can't contact the children at all. I think you guys know, those of you that go out and apply for protective orders a lot, that's pretty common for that temporary ex parte protective order. It might say no contact, and then the court might reconsider when they actually have the hearing for the final protective order. So at that hearing, in this case, Brady Ethridge, the father, he testified about how she had injured the children. He had medical records. The mom, Christine Stary, she denied it in her testimony, but ultimately the court found that she had committed felony family violence. They issued a lifetime protective order. Those are kind of rare here in Texas, but we do a lot of them at TAP. They do happen. A lifetime protective order. And in that order, they prohibited all contact between Christine Stary and her children. And Marshall, am I right that the father, Brady Ethridge, hadn't specifically pled for that?
He had, yes, he had in the original application. I'm not sure it was included in the original application, but in a subsequent application,
Oh, okay.
it was sought, and it might have only been in the original until they turned 18. But it was eventually pled in before the court at the hearing.
Do either of you have anything to add to the basic facts?
I'll just add that while she was only arrested and charged for one instance, there were multiple instances of evidence presented at the hearing that would likely have also been able to be charged as felony injury to a child. So there was extensive evidence that was presented to the trial court that supported a protective order lasting longer than 2 years, which is kind of where we hit the rub with the Supreme Court later on.
Well, after this decision came down at the trial court, it was appealed. So that goes up to like the next level of courts. The Court of Appeals for the First District of Texas, they considered it and they affirmed, which means they said, yes, the trial court made the right decision. So they said the lifetime protective order protecting these children, saying that the mother, Christine Stary, could have no contact with them. They said they're going to uphold it. And the argument was, well, is this not okay because you're essentially terminating her rights to her children? And when we do those kinds of cases, there's a higher standard of proof. So they considered the question. We'll talk more about that question in a second, but they were like, no, it's fine. They had one justice dissenting, and he said, they said, yes, we do think it is like terminating the parental rights. So let's talk about that for a second, give you that background. Termination of parental rights. This is, many of you know this, sorry, but this is the term in Texas for when the court dissolves that parental relationship, where they say legally you're not this child's parent anymore. There's a very high standard of proof for this. You have to prove it by clear and convincing evidence, which we will talk about later, what that means exactly. We do terminations of parental rights here at Texas Advocacy Project. If, you know, when there's been abuse of the children, sexual abuse of the children, things like that, that's a good remedy, I think. So they're still your biological parent, but legally they're not your parent. If anyone has questions about that, go ahead and put them in the chat. And Michaela, do you have anything to add to that?
I just know as a former prosecutor, so beyond a reasonable doubt is the highest standard, and then it's clear and convincing. And then cases we primarily deal with, it's preponderance of the evidence, so 51%. And I just remember as a prosecutor, when we would do voir dire, defense counsel would always say, beyond a reasonable doubt is even higher than terminating a parent's rights to their child. So just when you're thinking of standards of proof, clear and convincing is right below beyond a reasonable doubt.
That's a great example, Michaela. Thank you for sharing that. I stole this definition from texaslawhelp.org. So if you want to learn more about it, they have a page all about this on their website, texaslawhelp.org. Okay, so now we're at the part of the case. It's already been to the trial court, it's been in the appellate court, and now it's going up to the Supreme Court of Texas, and this is where Marshall gets involved in the case. Marshall, will you tell us your role in this case?
Yeah, so this was sort of an unusual procedural posture for the case. The father, Brady Ethridge, who sought the protective order against Christine Stary, did not file a brief in the appellate court and the intermediate appellate court, nor did he respond to the Supreme Court of Texas request for a response to the petition for review. So when you file a petition for review in the Supreme Court can request a response. And here, Christine Stary filed her petition. Supreme Court asked for a response from Mr. Ethridge, and he didn't respond. And they asked him again, and he didn't respond. So he's just sort of checked out of this case, even though he's the one that obtained the protective order. We'll talk about this later, how this can be kind of a difficult wrinkle in these proceedings that are brought by private parties, not the state. And if somebody loses resources or interest in the case, then there can be a real disadvantage to survivors. But so because the Supreme Court was clearly interested in this case, because of the constitutional question that we'll talk about of the standard of proof, they sent a letter to the pro bono committee of the appellate section of the State Bar of Texas and said, hey, we're interested in this case. The respondent, Mr. Ethridge, won't respond to our request for a petition. Is there somebody out there who we could appoint to basically argue the other side, to defend the Court of Appeals judgment? And one of my colleagues at Butler Snow, Amanda Taylor, I remember I was in Houston at a wedding with my wife, and Amanda texted me and was like, hey, did you see this order? Like, this could be an interesting case. Maybe you should see if you could get appointed. So I emailed the chair of the pro bono committee for the appellate section, said, hey, I clerked at the court. I do a lot of appellate work. This is an interesting issue. I'd be happy to take this on pro bono. And so she sent a letter to the court saying, hey, Marshall Bowen would be a good candidate, and the court promptly entered an order appointing me for purposes of preparing briefs on the merits and arguing the case if they granted the petition. And I had a sense that if they were going this far to seek amicus counsel appointment, they were likely going to take the case and set it for argument. So I was appointed. I filed my brief kind of in this awkward posture of I didn't represent anybody, but I was just defending the Court of Appeals judgment. So defending kind of the position if Mr. Ethridge had filed a brief arguing that the trial court did not abuse its discretion and applied the proper standard. That was the argument I was tasked with making. And then Christine Stary's lawyer filed a response. I filed a reply. TAP and a few other groups filed amicus briefs, a combined amicus brief in support of my position. And then the case was set for oral argument in the end of October of last year, and I argued it. Do you want me to pause there, Bronwyn? Or
That's a good place to pause because I
Okay.
do want to have you talk more about that. I really do. So this is all kind of unusual. I think it's interesting. Thank you for sharing this. You guys understand amicus is a Latin word. It means like you're a friend of the court. So the Supreme Court of Texas, Marshall's their friend. They picked him out to come be a friend of the court. And we were really lucky that Liz Boyce, formerly at the Texas Association Against Sexual Assault, she wrote another friend of the court brief, like Marshall said, and the Texas Council on Family Violence and TAP joined in. So we were representing all of you and your thoughts on this. That basically you know, it's important for protective orders to have that standard of preponderance of the evidence, that lower standard, easier to get. Very important to all of us. So then we get to the place where oral argument happens. That's not something like Tap and Liz Boyce and all of us would get to do, just Marshall. But another interesting thing happened in this case. They did not hear the arguments in their big fancy building in Austin. They actually went on the road and they made up a little courtroom in Houston at the University of Houston Law Center. So Marshall was there, and you can unpause, Marshall. We're at the part where you're having oral arguments last year.
Yes. So this was my first time arguing in the Supreme Court, which was a really cool experience in its own right, but also interesting to be arguing in a law school classroom that had been retrofitted as a Supreme Court courtroom. I gave Blake Hawthorne, the clerk of the court, a hard time that my office at the time was right next to the court. And so I got to drive, to Houston to present argument when I otherwise would have walked across the street. But it was a really interesting argument, a very lively panel. So I think I got through, maybe you can go watch the argument if you're curious. It's on YouTube on the Supreme Court's website. And I maybe got through, if you watch it, you'll see I got through, maybe 30 seconds before I started getting questions, and that continued for my entire 20 minutes. I had 20 minutes to argue, and I had come with, a lot of thoughts and ended up answering questions, which I preferred because that showed me that the court had read the briefs, was interested in the case, and really wanted to dig in. And we got into all sorts of areas of my arguments. My arguments in my brief and at the oral arguments were really centered around the fact that this is not equivalent to termination, that termination is the most extreme remedy. There's no further possibility of modification after you exhaust your initial appeal, that it strips a mother or father of all of their legal rights and duties with respect to their child. And this protective order was more like a child custody order that prohibited contact or possession of the children. And so my argument was that because of the difference, that if you think about parental rights as sort of a bundle of sticks, as the court has talked about, or a bundle of rights, that this removed some of those rights, but it kept intact other rights. And because of that, it was okay that the trial court applied this lower evidentiary standard. And there's case law from the Supreme Court, from prior opinions, talking about how, it's in fact good for trial courts to consider less drastic means than termination, that termination is sort of the ultimate highest intrusion into the parent-child relationship. And when you have evidence of abuse, felony level abuse, my argument was this is sort of a necessary middle ground, that while it seems drastic, and it is drastic, so is the abuse here. And this is a necessary measure to protect the survivors, these children, from further abuse. And I think making this even more, in my view, what I thought was more compelling was that the protective order, like all protective orders, can be modified. And so this protective order could be modified on the mother's motion twice. And in fact, when I argued this case, she had already initiated a proceeding to modify the order that was pending in the trial court. And that, as best I could tell from the dockets, they were just sort of continuing that modification proceeding until the Supreme Court case wrapped up. But there was already an effort to modify it. And then I argued that there's no reason that any of the children or the father, if circumstances changed, couldn't come an infinite number of times and attempt to modify it. There's no statutory limit. The mother, the person who's subject to the protective order gets 2 times, but other parties could modify it or move to modify it as many times as they wanted. And then additionally, this protective order specifically contemplated reunification. It ordered the children to be in counseling and for mother to be in counseling. And so there was the order itself, specifically imagined a world in which the protective order would be modified to allow mother to be reunited with her children. So I thought, I argued all of those facts made this distinct from a termination proceeding. And that's where a lot of the questions at oral argument were, well, isn't this just essentially termination? Because if you take a mother's right from being with her children away, you can say there's all these other rights, you know, the right to say where they go to school, have a say in their healthcare, but if she can't actually be with them, I mean, that's the most important right. And I agreed with the court that that's a critical right, but if we're talking about the legal termination of rights, which is a specific legal proceeding, this is not the same thing. So that was, we kind of went back and forth on that for my entire 20 minutes.
Thank you so much for sharing that, Marshall. I think that, you know, a lot of times us in the movement, we are working more at like, we're meeting survivors, maybe we're accompanying them to court at the trial level, but we don't do as much work at the appellate level. So it is great for us to hear how, you know, if a decision really isn't right, we could appeal. There are pro bono attorneys out there. Michaela, you were in the audience. You took this picture on the right for me, this slide. It sounds like they had tons of questions for Marshall, but did you, I mean, those arguments sound great to me. We were definitely supporting Marshall's argument. What was your impression watching it?
Yeah, we were talking prior to this. We definitely, I felt like we definitely had some justices on our side by their questions of Marshall. I think they were really focused on why a termination lawsuit hadn't been filed in this case. I remember them asking both parties about that. They also wanted to know how many years would be sufficient if they changed the standard of proof. So do we apply clear and convincing if it's a person who's seeking a family violence protective order over 10 years versus 5. They wanted to know if they put a time limit on it. I guess that might make a difference. And then really, what would the consequences be for heightening the standard of proof? I remember them asking both Marshall and other counsel about that. So I really thought, I mean, one of the justices was, I thought she was really on our side. So it was interesting to see their opinion and who actually authored that opinion.
Yeah, it was interesting. That's a good point, Michaela. And I think it was, you know, I thought based on how the questions were going in argument that there might be, that this wouldn't be a unanimous decision, that there would be a dissent or it would be a split decision. So I was surprised when this came out in May of this year that it was a unanimous 9-0 decision. And I think one point Michaela raised, which was the questions that came up about why wasn't there a termination proceeding. And that's something that's not clear in this case in the record. CPS was contacted a number of times in this case. I think it was 6 or 7 times and declined to intervene. And so there was never a termination proceeding brought by Mr. Ethridge or by the state. And that was, the court was really interested in why that hadn't happened. You know, if and they're sort of, I think the point was, well, if this really warranted termination, why didn't somebody just move for termination? And the record wasn't clear on that. And the other thing I'll add, Bronwyn, you mentioned earlier that, and the court talks about this in the opinion, that the state dismissed the criminal case against Ms. Stary in February of this year. So, you know, almost 5 years after the charges were filed. And that had not happened when we argued the case or when we briefed it. So you know, the court kind of had the benefit of that piece of the facts coming out after we argued and briefed the case. And I don't know to what extent that might have weighed on their thinking if the state abandoned the charges, you know, that they thought that cut against. But that doesn't change their ultimate conclusion, which is that any case like this, if it's more than 2 years and it affects a parent's right of access or possession to their children, or prohibits all access or possession to their children, then it must meet clear and convincing evidence.
Yes, let me put that up on the screen so that if you're like me, you have to read it. But Marshall already shared they overturned the protective order. They said they're reversing it and they're going to send it back, in theory, send it back to the trial court to reconsider. And I have that language Marshall was just sharing up in case you're a reader. I think that the facts that you just shared, Marshall, are very interesting for all of us in the movement, because we have a lot of times where we're working with a survivor of domestic violence and there's a criminal case. Maybe there's an arrest And we're kind of thinking like, oh, okay, well, if someone's arrested, they're in jail, maybe there's bond conditions. Are you safe now? Is it over? And in the movement, we'll talk to people and say, hey, maybe you still want to go get that protective order because we don't have control over the criminal case. Those charges could be dismissed even. But if you file the protective order, you're in charge of that case, and you can protect your own safety. So this is a good example of that, kind of the parallel things. You can see the opinion here, and the language that they used. Ultimately saying a lengthy protective order that is prohibiting contact with a parent and a child is essentially the government terminating someone's parental rights. Now, reading this is what made me want to invite all of y'all here today, because I think that there's a chance people can misinterpret this. And I want everyone here to just be super knowledgeable and smart about what it means and what it doesn't mean. And we'll kind of go into that next. But I think ultimately this ruling reflects that the court does want to balance survivor safety and due process. They always have that top of mind. Like, we want people to be safe, but we have to follow the Constitution, have people have due process, right? But this is a new precedent. This was not the law before it came out, and it is the law now. It is a change. So it's going to change how survivors ask for and obtain protective orders. Let's go back to what clear and convincing means. Michaela, you explained this really well, that it's kind of it's levels of proof. Like, how much do you need to bring to the table to get what you want from the court? So if you'll just, I don't need you to repeat yourself, but like, if you'll share one more time, like, what is the implication of this compared to what the law was before the ruling came out?
So yes, the before this came about, it was preponderance of the evidence. So we like to explain that as 50 versus 51%. So just a little bit above 50%, and you're at preponderance of the evidence. So that's what a lifetime protective order involving children was prior to this going before the Supreme Court. And then the next standard that we're looking at is clear and convincing, which is what they heightened it to. And then I talked about beyond a reasonable doubt is the highest standard of proof. So yes.
So it has made it harder to get this particular clause. When I'm talking to survivors about a protective order, I say, look, we're going to go to court. You're going to share your story. And they might say, well, I don't have a video of it happening, so I don't have proof. And I said, well, actually, you're telling the story on the stand. That's testimony, and that's a type of proof. So it's very rare to have a video of it happening. And a lot of people don't even have medical records or police records. But if you're an honest and believable person and you tell the truth on the stand, the court just needs to figure out that it's more likely that what you're saying is true than not. Just more likely than not. 51% sure, preponderance of the evidence. That's all that. So now, if you're going to ask for these particular clauses, it's a little higher. You have to have enough evidence that they have a firm belief or conviction that it's highly probable. I know that those words sometimes you're like, well, what percentage is that? There's a lot of cases trying to explore, like, what does that mean? But it's more likely than not. So that he said, she said, I hate that phrase, but like, that would not be enough for clear and convincing. So just your testimony versus someone else's testimony would not be enough. I hope that gives a little clarity, because I do think this is kind of like a hard thing to get your head around.
Yeah, sometimes I think about this standard Bronwyn is if like
Please.
Preponderance is like 51% and beyond a reasonable doubt is like 95 to 99% or something. Maybe this is like 70%, right? I mean, maybe we kind of like split the difference between, preponderance and reasonable doubt. And so that's maybe another way to think about it.
Yes, that's helpful.
I feel like now that the standard has changed, we'll see what courts, how they're interpreting what level of evidence they need to see in order to reach clear and convincing. So it'll be interesting to see, opinions coming out with, that's going to be a while, but to see what they amount to as enough for clear and convincing? Is it testimony and credibility of witnesses, or do they actually need to see medical records or photos and things like that? So.
Exactly. So before we move on to the second half of this, like, what does this mean for survivors? What does it not mean for survivors? I just want to like bring us back to the people in this case, the mother and father, Christine Stary and Brady Ethridge. So what this meant for them, as opposed to the rest of us, is that the father, Brady Ethridge, he could set another hearing in front of the trial court and have them reconsider his case with this new standard. I actually think, after talking to Marshall, he probably had enough evidence to meet this standard, and they probably, at the end of the day, they'd give him the same protective order, but it doesn't look like we're ever going to find that out. Is that right, Marshall?
Yeah, it's hard to know because I haven't been in touch with any of the trial counsel or anything, but it seems like he hasn't been involved in this case. And I mean, the Court of Appeals opinion came out in 2022, and he didn't file anything in that court or anything in the Supreme Court. So I think the chances that he would refile on remand for a new hearing is pretty slim. But I do think the evidence in this case, back to Michaela's point, is, I mean, there were medical records, there were photos, there was testimony. I mean, so there was a lot of evidence in the record supporting and demonstrating that not just one instance of abuse, but multiple instances of abuse. And so I think it's unfortunate that this likely won't go back to another hearing, because I think this would be a case that even under this new heightened standard might satisfy it.
I agree. I think it would be great if it went back and they got the protective order, because then we could all, you know, the advocates, we could say, yeah, they made that standard, but look, in this case, they still got the protective order. That would have been nice. Okay. Everyone is now an appellate court genius, appellate law genius. I appreciate y'all coming on that journey. So what does this really mean for survivors? They have ruled you have to have that heightened standard of proof, clear and convincing evidence in protective orders for prohibiting a parent from contact with their children. They said for more than 2 years. So I know in that case, we were talking about a lifetime protective order, but in their ruling, they said more than 2 years, because 2 years is this kind of standard length here in Texas. I think this is actually a pretty rare situation. I think they really did narrowly decide this, and we all need to know that and enforce that and let people know this is actually pretty narrow. We don't want anyone over interpreting it and saying all protective orders have this higher standard. No. And even like, you know, if it was a 2-year protective order saying no contact with children, still has that lower standard. So I think that's confusing, and we are going to need to help fight through that confusion and not have this be over interpreted. I put some bullet points together here for things I want everyone to know. We're just going to go through these really quick. What does this mean for survivors? This means all of us, all the advocates here, if you're going to go help somebody get a protective order that's longer term and it's going to prohibit contact, you need to be prepared to bring more evidence. Even if you get a default, and just, I think everybody knows what that means. When I help somebody file for a protective order, Michaela, your experience might be different, but about half the time, the other party does not show up. And that's like a little league softball game. If they don't show up, you win. It's a default. So if you have this kind of request and you're going to have a default, you still need to be putting on the evidence, you know, that you have these medical records, these police reports, other witnesses, you know, something more than just your testimony. Great suggestion that I got from one of my colleagues is that if you are pleading for a protective order like this, and you say, hey, no contact, that abusive parent and these children, no contact, you might want to write no contact subject to a custody case that could happen later. I think something like that would show, maybe even show a little bit more than happened with Stary and Ethridge, that we're anticipating a custody order coming and changing this. Now, also a third point, thinking about survivors, you need to prepare your client that, you know, they need to know protective orders can be modified. There's not really a limit on how many times they might need to modify it. There are limits on, you know, how many times the abuser can come modify it, but you need to prepare them that somebody might want to come and try to modify that protective order now that there's this new standard, that we could see a wave of those. I don't know. So bottom line, if you know someone who has one of these longer term orders and they think that's keeping their little children safe, this might be time to call TAP and let's go ahead and get that termination. If we can show the protective order in the termination case, we can get that termination, we can give that lasting permanent safety for the child, which is, you know, the Ethridge children don't have that right now. Anybody here have anything to add to that? Michaela, Marshall, or anyone else want to chat? Those are my key takeaways.
Yeah, I think it's really important to focus on how narrow this opinion is. You know, it's only on no contact, you know, prohibiting all contact between a parent and a child for longer than 2 years. So you can see how quickly you might get out of that universe, you know, if it's not between a parent and a child. If it's between a parent and a child and it's some contact, you know, all of a sudden you're outside of this higher standard. So, you know, this is a really unique situation. And I think you touched on this, Bronwyn, but just keep in mind that if, you know, there are no contact lifetime protective orders out there right now that are certainly subject to modification in light of this opinion. So I don't think that legally they would just automatically be void, you know, on their face, but that would certainly be a basis for somebody to move to modify it and say, hey, this protective order was entered under the preponderance standard, you know, in 2018 or something. 2025, the Supreme Court says you got to have clear and convincing evidence. Trial court, you need to dissolve this protective order, and the trial court would have to do that. So I don't know how many of those are out there, but that's certainly something to think about.
That's a great point, Marshall. I know at TAP, especially with cases of child sexual assault, we are getting those lifetime protective orders, no contact. I love your point though, if it's not no contact. So maybe we'd want to think with our client, okay, I know this person is dangerous. Is there any level of contact that you would consider safe? Like, would you consider phone calls safe? Would you consider FaceTime safe? You know, that's very case specific. But even something like that might mean this opinion isn't relevant. Yeah,
I think that would easily take it out of this, you know, because in this one it prohibited even phone calls or any talk. I mean, it was a no contact, you know, zero. So I think at the second you introduce some level of contact, you're outside the scope of this.
That's going to be a real strategic conversation attorneys like Michaela are going to have. They're going to say like, okay, what kind of evidence do we have to bring to the table? If it's just your testimony, maybe we want to throw in there that we would allow phone calls with the children to keep the standard of proof low.
Yeah, I just wanted to kind of jump off that really quickly too. So a colleague and I got a lifetime protective order last summer for mom and kiddo. And so kiddo was included in the lifetime family violence protective order, but there's a very specific supervised visitation schedule in the protective order. So it made me feel what Marshall just said a little bit better, because of course when this opinion came out we were looking at each other like, oh no, but because the father has some sort of contact with the child through those supervised visits, we feel better that hopefully it will be okay.
Yeah, thanks for sharing that, Michaela.
Mm-hmm.
So just bottom lining, what does this not mean for survivors? This does not mean we're raising the standard for all protective orders, just for those specific situations. And we really don't want this case to be an excuse to not include children in protective orders. I know sometimes, depending on where you all are living in Texas, it can be really challenging to get a court to include children in protective orders. We have that experience, and I'm worried that people will bring this case up and say, let's not have the children on the protective order. So I hope all of us keep trying to work for that, ask for it, bring evidence to support it. And I want to plant a seed with all of you, our friends around Texas. I think that this is part of, why did this happen? I think it's part of a pendulum swing back you know, for decades, protective orders in Texas legally have been getting more expansive and better and more accessible for survivors. So this is like a restricting of that, which is a change. We saw that try to happen last 2 years ago with Rahimi, the case that was trying to say, well, you can't prohibit the firearms, but ultimately the Supreme Court of the United States said, no, we're going to leave that the same. But, you know, I think we've also, I won't go on my soapbox about this, but like after the Me Too movement, we saw a pendulum swing where people aren't maybe quite as, the public isn't quite as supportive of people speaking out, that kind of thing. So I'm sharing, I think this article, this is a blog from one blog from a law firm. I think this is a great example of like negative propaganda out there saying protective orders are too easy to get. People are just getting them to have an upper hand in a divorce. People are lying about abuse. Like, we've all heard those things. And I'm worried that this kind of case could be used by that movement. So just watch out for that. Why is that a big deal? We know there's a huge link between domestic violence and children. I have a statistics here in approximately 30 to 60% of families where there's, you know, child abuse or adult domestic violence, there's the overlap between them. So it's the same person. In homes where there's domestic violence present, the safety of a parent who's the victim of domestic violence is really intertwined with the safety and well-being of their children. We say this all the time. All of us here on the call, the best way to keep those kids safe is often to keep that protective parent safe, right? So enhancing the safety of that parent enhances the child's safety. I'll let you know, this is our last slide, make a pitch. We're doing our regular annual survey right now. We call county and district attorneys across the state of Texas and we interview them. How are you helping survivors with protective orders? And we're putting that into a report we're going to publish and distribute. All of y'all can get it, like have another town hall about it if you wanted to come. But I'll tell you what happened in the calls I made. About maybe 25% of the counties, they're not going to represent survivors. So in 25% of the counties in Texas, the county and district attorney aren't taking these PO cases. So those are times where you would need to find a pro bono attorney like Marshall, go to a legal aid or call Texas Advocacy Project.
And we would love for you all to just take a quick survey. You can use your phone and use the link just to share your experience and any questions. Can we take questions? We have a little bit of time.
Yeah, I'm happy to. And Bron, one other point I just want to make about the opinion that I don't think we got to is it also requires a finding by the trial court that the protective order is in the best interest of the child or the children. So in addition to this clear and convincing evidence standard, if it's a no contact order over 2 years, there also has to be a best interest of the child finding, which there was in this case. The trial court found that this was in the best interest of the children. And the trial court did that after having an in-camera, or in other words, like closed door meeting with the children individually, with the children's amicus counsel, appointed counsel present in the judge's chambers. So,
Wow.
you know, for me, that was a compelling piece of the story here, was that the judge met individually with each child before reaching this decision. So that's something else to just think about as this plays out going forward.
They must have really thought, the Supreme Court of Texas must have really thought, hey, this will go back down to the trial court. They'll reinstall the protective order, make the little extra finding, and we'll have made a narrow decision. So it is unfortunate that that doesn't look like it's that final step will happen here.
Yeah, I think my final thoughts on that are this, you know, they were not thinking about, you know, they were thinking about sort of the worst possible scenario from a constitutional standpoint in reaching this decision. I mean, this case might, that's why I think they remanded it, because there is evidence here of that might justify clear and convincing, but they're thinking about some other case, right, where it's way less evidence, you know, just one testimony, no charge, no medical records, and then all of a sudden you get a lifetime protective order. I think it's that case that they're concerned about in going too far. And so, which is why I think they remanded. They didn't, you know, they didn't render judgment here. But like we talked about earlier, I'm not sure we'll ever see another hearing in this case.
Thank you, Marshall. I was seeing a question in the chat. Kara asked, when terminating parental rights, is that like you're completely off the birth certificate, like an adoption? Essentially, yes. It's saying legally, this is not your parent. So legally, when you're 17, it's not your parent. Legally, when you're 18, it's not your parent. Legally, when you're 19, it's not your parent. Now, when you're 18 or 19, the legal parental rights that your parent have over you are really going away. So, you know, as you grow into an adult, that's still your biological parent. Maybe you would have some kind of relationship with them when you become an adult. So I think that's what you're anticipating, Kara. Let's say that child whose the parental rights are terminated, you know, they're 19 years old and they want to call that person and like go to coffee. They could do that if they wanted to, as adults, but that legally that person's still not their parent, although it doesn't. So the frequently the only thing that would happen at that age is you're looking at like your right to inherit from someone. So sometimes when people terminate parental rights, it's possible they could leave that right to inherit, or you can contract in someone's will. They could say, oh, I still want my biological child to inherit from me. I don't know if that's what you were thinking about, but if I didn't answer your question, Kara, please chime in. Oh,
Miguel had an interesting question. If the person subject to the PO exhausted their attempts to modify, would these changes allow for new attempts? That's a good question, because by statute you're only given 2 attempts to modify. I'm trying to think of procedurally what would be the motion. I mean, I think there's probably some avenue where you could collaterally attack the protective order after this opinion. But that's an interesting question.
I mean, could they appeal it? If it
I think he's talking about if you've already exhausted your appeals, like if you've, like let's say you had yeah,
maybe so. I guess, Miguel, like from an advocacy standpoint, if you're thinking about someone out there in the world that has one of these and you're like, uh-oh, like it is good to think, uh-oh, we want to think like, okay, could somebody still go challenge this? So you all have anticipated all the ways it could be challenged. They could modify it the right number of times. They, you know, there is an appeal process for protective orders. We might want to go look at a termination for that client, Miguel, if that's a client of yours. I love that y'all are asking questions. If you have more questions, please put them in the chat. Or if Michaela or Marshall have any more thoughts, just jump in. Oh, Daniel is saying they were unaware that not all counties help with protective orders. Can you have a list? Yes, you can. We are going to be publishing this report and the research that we have, and we will absolutely be happy to send it out. We'll have it on our website. Probably y'all will know. Follow Tap on Instagram. You'll see when this comes out. If you want to reach out to me privately, I'm happy to look up any county you have a question about now. I don't mind sharing that. Hey, I'm looking if there aren't any other questions. I'm just so grateful. Marshall, thank you for taking this case on and making the best arguments we could. And I think thanks to you, we did get this narrow ruling. I think that's really good for sure. Oh, I do see one more question. If y'all are still here, somebody has a question. Elizabeth says, is there a way for people to appeal refusal to hear a PO case if there wasn't a police report in those jurisdictions? Elizabeth is bringing up something that's coming out in our research. So if you go to your county or district attorney and you say, hey, will you help me file for a protective order? Will you help me apply? And they say, no, we're not going to help you. You don't have a police report, even though that's not required by the law. If they say, no, we're not going to help you, that doesn't mean your protective order was denied. It just means those humans aren't going to help you in that case. So then you need to go out and find other people to help you, Elizabeth. So your client could hire an attorney, get a pro bono attorney, go to legal aid, or call TAP, and we could help them bring that forward to the court. Now we are finding, there's actually a study that was commissioned by the legislature, and the Office of Court Administration found there are judges that are denying protective orders when there's no police report, you know, just out of hand saying no police report. And that's not a legal requirement. So that's another thing we're kind of like keeping an eye on. So maybe that's what you're asking. I hope that answered your question, Elizabeth. If it didn't, please email me. My email's on here. Thank you again, Marshall. Michaela, thank you so much for joining us. Michaela is helping TAP develop more of our law center work and doing more advocacy and impact work like this. So thank you both for joining us, and thank you all for being here. I really appreciate it. Let's push out the message. This is a narrow ruling, and we are all going to come to court with survivors prepared to meet their goals and get what they want.
Thanks, Bronwyn, for having me.
Thank you.
Thanks. Bye, everybody.
Y'all have a good day.